All rise.
Further hearing in the appeal, SB Children.
Yes, Miss Grocott.
Lord, yesterday I said I would begin what I described as the defence of Lord Nichols. We'll try and take that as shortly as possible. In doing so, the local authorities case is, of course, that RE restated the law rather than altered in any way the law as set out in REH and others.
Yeah.
And contrary to the suggestion in the appellant's case that Lord Nichols expressly set out a heightened cogency test, he did nothing of the sort. That was recognised in particular by Lord Hoffman in RE in paragraphs 11, 12 and 13. Before I turn to those paragraphs, perhaps it is more sensible to return, my lords, to, I'm afraid, 1996.
To what?
1996, and to the decision at tab 12
This is REH.
in REH. Specifically, page 17. There is no easy way of identifying page 17.
Well, this is 17 in the All England.
In the All
numbering.
England.
Yeah.
Yes.
Is it routine in family appeals to get reports in this form?
Well, my lord, certainly there has been what would be regarded as slippage in what was the orthodox practice of referring certainly to the appeal cases as the authoritative report. The difficulty, and indeed in part that difficulty will arise for the reasons I'll set out later.
Well, I don't want to spend hours on it. I just wondered if we're always going to have this sort of case. No, okay.
Well, my lords, I would certainly exhort anybody preparing a case for consideration to use the appeal cases, not least because the arguments that were before the House on that occasion are set out.
In your index, actually, you give the appeal case reference, so I was a bit surprised to find this in this form, in view of the way it had been introduced.
Well, my lords, yes, it threw me yesterday because, of course, absent in these authorities is some of the material that may or may not be germane to understanding how the issues were put and the decision arose.
Yes. Anyway, you're asking...
The printout form, it's also...
The printout also is not user-friendly. It would need an internal pagination for ease of reference, which we have not got.
Anyway, we're looking at All England, page 17, are we?
Indeed, yes, my lords. The standard of proof at the top of the page and the parallels, which are said to have led to a heightened cases, have not continued and included the paragraph at the bottom of the page, beginning no doubt, carrying over to the other page. But having considered the approach in Morgan and UKSC, Lord Nichols went on to say this: no doubt it is this feeling which prompts judicial comment from time to time. Grave issues call for proof to a standard higher than the preponderance of ability. Similar suggestions have been made recently regarding proof of allegations of sexual abuse of children. See RE-G and RE-W. So I must pursue this a little further. The law looks for probability, not certainty. Certainty is seldom attainable, but probability is an unsatisfactory, vague criterion because there are degrees of probability. In establishing principles regarding the standard of proof, therefore, the law seeks to define the degree of probability appropriate for different types of proceedings. Proof beyond reasonable doubt, in whatever form of words expressed, is one standard. Proof on a preponderance of probability is another, a lower standard having the inbuilt flexibility already mentioned. If the balance of probability standard were departed from, and a third standard was substituted in some civil cases, it would be necessary to identify what the standard is and when it would apply. Herein lies a difficulty. If the standard were to be higher than the balance of probability, but lower than the criminal standard of proof beyond reasonable doubt, what would it be? The only alternative which suggests itself is that the standard should be commensurate with the gravity of the allegation and the seriousness of the consequences. A formula to this effect has its attraction, but I doubt whether in practice it would add much to the present test in civil cases, and it would risk causing confusion and uncertainty. As at present advised, I think it is better to stick to the existing, established law on this subject. I can see no compelling need for change.
So aren't you in effect saying that when Re B said balance of probabilities, balance of probabilities, balance of probabilities, we were simply reaffirming what Lord Nichols had said, and anybody who read the intervening paragraphs as meaning that if there was a serious allegation, the proof had to be heightened cogency, had misunderstood what Lord Nichols had said?
Yes.
But it's very difficult, that.
It is very difficult.
It's very difficult, that, because it's always been recognised that that cases like Hornell and Neuberger, Reed Dello's Will Trust, and a whole series of cases introduce a gloss. You can call it balance of probabilities till you're blue in the face, but there are the cases that say that if the allegation is whether A murdered B, and there are lots of cases that say, well, you really have to be sure in order to be satisfied on the balance of probabilities. Now, I thought that the effect of B was to dispose of all that baggage and simply ask the simple question, did the fact occur on the balance of probabilities? Of course, you have to take account of all the circumstances of the case in answering that question. But speaking for myself, it appears to me that we have to grapple with the question, are we still to look at Reed Dello's Will Trust, are we still to look at Hornell and Neuberger in order to apply the standard?
No, my lords, but we never were
Whereas
directed
if you look at Lord
that.
Nichols, you'd think that you would.
Yes, because
he
he does refer to the inbuilt flexibility. I mean, isn't that his point there?
If you go back to page 1 of 8 on this thing, page 1 of 8, where the markup of page 1 of 8 is, just above that, you find Lord Lloyd, who dissented on this very point. All three counsel agreed that the correct answer to the above question should be 2. And 2 is, if you look back, the balance of probability is so more the serious allegation, the more convincing the evidence. In other words, the well-known test. As a result, there was no argument as to theoretical difference between the 3 possible answers, or perhaps more important, the practical consequences, nor any citation of value authority. So all these things were judgments which were then written without argument. And Lord Lloyd specifically dissents on this point. And he says that on the following page. So, I mean, there's no doubt that that's what Lord Lloyd thought they were doing.
No, my lords, I agree. In fact, Lord Lloyd commented specifically on this issue of appeal. That's 8.
Yeah.
And it was the Court of Appeal, having found that there was only one standard of proof, namely proof on the balance of probability.
It doesn't matter, really, this. I mean, it's a bit of history.
Yes, exactly.
But Lord, I understand the point clearly. Lord Nichols himself also agreed that the Court of Appeal were of the same view. He did not, in fact, dissent, but having discussed the issue of probabilities, he himself drew back from saying that such a test should apply, and he too disagreed, which was what the agreed formulation was at the bar, that it should be balance of probabilities, but with consideration being given to the gravity and to cogency and to probability.
Well, do we need to spend longer on this case?
My Lord, no, safe to say that the only other guidance that Lord Nichols does give in Re-H and others, which is relevant today and indeed, again, is in perfect symmetry with the decision in Re-B, are his concluding remarks at page 22. Conscious of the difficulties confronting social workers and others in obtaining hard evidence which will stand up when challenged in court of the maltreatment meted out to children behind closed doors, cruelty and physical abuse are notoriously difficult to prove. The task of social workers is usually anxious and often thankless. They're criticised for not having taken action in response to warning signs, which are obvious enough when seen in the clear light of hindsight. Or they're criticised for making applications based on serious allegations, which in the event are not established in court. Sometimes, whatever they do, they cannot do right. I'm also conscious of the difficulties facing judges when there is conflicting testimony on serious allegations. On some occasions, judges are left deeply anxious at the end of the case. There may be an understandable inclination to play safe in the interests of the child. Sometimes judges wish to safeguard a child whom they fear may be at risk without at the same time having to fasten a label of very serious misconduct onto one of the parents. And Lord Nichols goes on to say those are among the difficulties considerations Parliament did in fact address in the 1989 Act.
Yeah, we got the threshold test, which the Act sets out.
Indeed. My Lord, the next
And
case...
goes on to make the point that parents are not to be at risk of having their child taken from them and removed into the care of the local authority on the basis only of suspicions, whether of the judge or of the local authority or anyone else. A conclusion that the child is suffering or is likely to suffer harm must be based on facts, not just suspicion.
Yes. And as to a conclusion based on facts, if one goes to the page before, page 19, Lord Nichols sets out a conclusion based on facts, and the issues that were or the questions that were being raised yesterday are covered in part by Lord Nichols' approach to what evidence can be weighed or should be weighed. And the principal point that arises from this, of course, is, as one would expect, that conclusions have to be based on facts arrived at by the tribunal. And that, of course, is necessary in terms of that particular decision because of the issues that their lordships were considering. That is the test in the likely harm condition. In Lancashire and A, which is tab 15 of the authorities bundle, Lord Nichols was once again part of the composition of the House that determined that issue. Lords, if you go to page 99,
Would it be helpful, Ms. Grocott, not everybody on the court may be as familiar with these cases as you are. It might be sensible just to explain that this was a situation in which a child had been looked after in two households.
yes, my lady.
And suffered injury. And the problem was to tell in which household the child or children had suffered.
Yes. The judge at first instance had not been able to identify whether the perpetrator of injury was from household B, that is the childminder,
Yes.
or from household A, in which the parents resided. And the judge at first
The
instance...
legal issue, however, was whether the attributability criterion was satisfied when you couldn't answer that question.
Yes. And what was determined by the House in Lancashire was that public policy considerations must be applied. That if the judge cannot, as His Honour Judge G, as he was, could not identify which was the perpetrator, one could not say that the attributable condition was not satisfied, as against the parents.
Can I ask you, just for guidance, in your index, this case is described as Lancashire County Council against B, and it's the appeal case it's referred to. Is this one of these things like a chameleon that changes its numbering?
It is, my lord.
It
It is, just as Re-H and others is known to family lawyers as Re-H and R,
yes.
Lancashire and A is known as Lancashire and B. B, of course, was the childminder's child,
I see.
and at the Court of Appeal, it was accepted that in terms of likely harm, the absence of a positive determination as against the childminder meant that the criterion were not made out in respect of her and her husband's child, which left only child A, the injured child, of the parents.
Yes.
And so the considerations given at page 9, it's actually just before page 100, are set out at the top of that page. Reference is made to the House once again, interpreting the threshold conditions, reference to Re-Emma minors and Re-H and others. And quite clearly, as I've just outlined, on the present occasion, the point at issue concerns the second threshold condition, that is the attributable condition, and in particular, the care given to the child. And the observation of Lord Nichols, this appeal is another illustration of what Lord Templeman, in the Re-Em case, aptly referred to as the tyranny of language.
When we're interpreting statutes which allow the state to take children away from their families, perhaps we do have to pay fairly careful regard to the language.
Well, my lady, yes, and indeed, language alone did not necessarily assist in the protection of the child, which is why their lordships determined that for public policy reasons, it would be an absolute nonsense in a case of demonstrable injury, serious injury in this case, to child A, that because a court could not identify whether it was her parents or the childminder, that the condition would not be satisfied. But the issue that arose from such a public policy consideration is set out at page 103 to 104. I recognise that the effect of this construction is that the attributable condition may be satisfied when there is no more than a possibility that the parents were responsible for inflicting the injuries which the child has undoubtedly suffered. And in this particular case, there was certainly a possibility, not in the household where the question is, was it one parent or another, possibility that both parents in Lancashire and A were not in fact perpetrators of injury. For if it was the childminder, they would be going through on an assessment stage as possible perpetrators, though in truth neither had harmed their child, nor, because of the facts of Lancashire and A, would they have been on notice that the childminder if it was her, was harming the child.
I mean, all these cases are analysed helpfully by Lady Hale in B, are they not? I mean,
They are indeed.
paragraph 45 of B sets out the bit you've just shown us and earlier bits, etc., etc.
They are indeed. And
Yeah.
the only necessity of looking at these cases is to look at what decisions were being determined in those cases to assess whether the contention on behalf of the appellants that Lord Nichols, in the paragraphs that you've already been referred to, my lords, was in fact saying what he did in paragraph 32 on likelihood as a result of his belief in a heightened cogency test.
But is that really relevant? I mean, re-B now holds the field, doesn't it?
Indeed it does.
So whatever interpretation is placed on what Lord Nichols said, I mean, that has been either overtaken or simply confirmed by re-B.
Yes, and as I've already said, the local authorities case is that re-B did nothing more in terms of the standard to be, a test to be applied, than reaffirm what was the unanimous opinion. They were in majority and dissent on a different issue of their lordships in Re-H and others.
Is there anything missing from Lady Hale's analysis of this case in Re B?
No, my lord, there isn't.
So you're accepting the way she approaches it
Yes.
in that case?
I do indeed. The only thing that was missing in terms of the analysis of these two cases was the paragraph I've already referred your lordships to in Re-H and others in respect of Lord Nichols having postulated the possibility of the Roman II test, actually drawing back and saying, but there ought not to be a Roman II test. That is a heightened cogency test.
Yes.
Lord, that then takes us to O&N at tab 8. The Lords, as has already been explained, these were, there were two separate appeals, two separate children, each of whom had suffered proven injury. The brief facts that arise from the two appeals are set out at paragraphs 5 and 6 in relation to the child in the Re-B aspect, and 7 through to 11 in terms of the child L and C in the O&N aspect.
7 to 9, eh?
Sorry, 7 to 9. Yes, my lord.
Can I just stop you just for a moment to get my references correct? O&N, of course, is another thing. It changes its names a bit, doesn't it? It's referred to in the index of in Re B as O Re B. Is that right?
It is.
And I'm just trying to find where Lady Hale deals with this case in...
Paragraph 46.
Thank you very much. Yes, yes, thank you.
Through to paragraph 52.
Yes. Right. So you're taking us to the tab 8 then.
The tab 8 is yes, and the factual matrix arising from the Re-B aspect is paragraph 5 through to 6, and the O&N aspect, paragraph 7 through to 9.
Yes.
Look, it's in the Court of Appeal that suggestions arise of Lord Nichols considering the issue of a heightened cogency test. That arises because of the language used by Lord Justice Thorpe in re B. And my lords, that was already outlined yesterday, but so far as Lord Nichols is concerned, his understanding of the factual circumstances are as set out in 6. So far as 7 is concerned, the judge at first instance, the late Judge Downey, had made a clear finding that whilst the father was responsible for the skull injury, he had earlier pleaded guilty to other injuries and then retracted. And on the evidence, she could not determine, as between the two parents, which one had caused the other injuries.
Yeah.
And on those facts, in paragraph 9, the court, in the Court of Appeal, Lord Justice Ward, didn't disturb any of the judge's findings, but Lord Justice Ward said, "In my judgment, this case must proceed henceforth upon the clear basis and understanding by all concerned, lawyers, social workers and experts, that L was not harmed by her mother, and there is no risk that either L or C is at risk of suffering physical harm from her." And further, in that paragraph, that the judge's findings ought to be reformulated. Those were clear findings that, but for the skull injury, neither parent could be identified. It is not established upon a balance of probabilities that any one or more of these further injuries were caused by either the mother or father. Accordingly, the mother must be treated as if she did not cause L to suffer significant harm within the meaning of section 31(2) of the Act. Moreover, she is to be treated as if she had not caused L to suffer any physical harm or caused L or C to be at risk of suffering physical harm from her within the meaning of section 13E of the Act. Now, my lords, that case has some similarity with the present because the parents did indeed separate after the injury to the subject child, and the mother gave birth to a second child from the father. And so the issue as to whether or not the mother was to be treated as a risk based on perpetration was a live issue in respect of both children, but more particularly a live issue in respect of satisfaction of the second test, the likelihood of harm rather than actual harm in respect of the unborn, of the newly born child.
Yes.
Lord Nichols, once again restated at paragraph 12 the general points that arose in effect from Re-H and others. He said in paragraph 12, the same broad principle is applicable when courts or tribunals peer into the future and assess the likelihood that a particular event will occur. This is an inherently imprecise exercise so far as human conduct is concerned. In theory, it is a different exercise from deciding whether somebody did or did not do something in the past. Whether or not an alleged event occurred in the past raises a question of proof. In truth, the event either happened or not. This is not so with a future forecast. The future hasn't happened, and the future human conduct is never certain. But in practice, the past is often as uncertain as the future. The judge cannot know for certain what happened and can only assess the degree of likelihood that something happened. The same is true of the future. The decision maker has to assess the degree of likelihood that an inherently uncertain event will occur. The decision maker has to assess the degree of likelihood beyond reasonable doubt, more probable than not, real possibility, and so on, required in any particular legal context, raises a question of legal policy. Now, my lord, the policy that ultimately dictated the decision and the remarks of Lord Nichols in Rio and N is, of course, the policy that had been applied to the attributable condition in Lancashire, which meant, as I've already said, that both parents went through, in that case, when there was only a real possibility that they may have harmed a child, and in respect of both sets of parents in both appeals in Rio and N, one may have only been a possible perpetrator and the other a perpetrator, but that the courts could not determine on the balance of probabilities which it was. And inasmuch as it may be suggested, as I've already said, that Lord Justice Thorpe's formulation and belief in a heightened cogency test may have infected the decision-making in Rio and N, your Lordships will see from the factual substrata in O and N, and in particular the manner in which the judge's fact-finding was set out in paragraph 9, that it was a clear case of uncertain perpetrator, and the question was, what do we do in the next stage? That led to the paragraphs at 26 through to 36.
Yes, on his way, you can see in paragraph 19, he's really addressing this very difficult question about threshold condition B.
Yes.
So we get to 26, did you say?
Yes.
Yes.
I should have pointed out 19 through to 22 sets out that, if you like, legal history or legal chronology of how this litigation and how the interpretation of Section 31 has developed, concluding, of course, with Lord Nichols asserting in paragraph 22 that as a result of those factors, the House now has to consider some of the practical implications of the decision at the welfare stage.
Yes, but I mean, paragraph 13 seems to me very important, because Lord Nichols, for example, cites the case of Karan, which is a well-known case in the asylum sphere, and what he is talking about is real possibilities of past events taking place. In other words, he's not talking about making, I mean, the whole point about Karan was that it wasn't about making determinations on fact, on the ground of the balance of probability. On the contrary, and because it was an administrative thing which the adjudicators and so on were doing, you were to take into account real possibilities that things had happened.
Well, my Lords, paragraph 13 is, of course, an illustration that is provided as a result of the observation in paragraph 12.
Yes.
It is no more or less than that in terms of decision-making.
I mean, what do you say about it? Is it right?
It isn't a
It isn't
factor.
right.
It is not a factor that has gone forward into the test, the balance of probabilities test for determining harm or likely harm. It is an observation that, for different reasons, different tests have been applied.
It certainly must have been what Lord Nichols was thinking about when he was saying the rest of his judgment.
Well, my Lords, that is why going back to the original authority and looking through what follows is in fact necessary, because it's a bit like the taking of paragraph 32 in this and to say that that likelihood means X or Y. In order to understand what the likelihood, the sense of it, one has to look at how that position was reached. And
so do you say, I mean, I just clear in my own mind, are you saying that Lord Nichols was wrong in paragraph 13?
I'm saying he merely made an observation, but it had nothing whatsoever to do with...
I would like an answer to the question. Was he wrong in what he said in his paragraph 13?
No, he wasn't, because he was talking about legal policy, but he talked about legal policy in the context that that was what the House of Lords had to do in Lancashire and A in terms of attributable condition.
What he's saying is, I mean, he treats past events and future events in the same way. That's what he says at the end of paragraph 12. Now, he may not be right about that, because there's plenty of authority that in past events you decide what actually happened, balance of probability. Future events, you can say it's a 30% chance that it's going to happen, and all these cases about pregnant servicewomen all proceeded on the basis that you assessed what chances there were of them actually having gone on working for as Wrens and so on, and being promoted and all that sort of stuff. That was all in the future, and they got compensation depending on the percentage chance which was determined. And that's what really Lord Nichols is talking about. He says you look at the past, you look at the future in the same sort of a way. Now, I just don't think that seems to me what he's saying in paragraph 13.
But Lord, it's clear, going back to Re-H and others, that that's not what Lord Nichols was in fact doing at all.
This is the point that's being put to you. If you read paragraph 13 literally, it looks as if he's contradicting everything in H and R.
Indeed.
I mean, both the principal point in H and R, which was that you have to establish the facts on which you make your predictions on the balance of probabilities, which was what H and R was really about, and of course the whatever he did mean about heightened cogency seems to be resulting from both of those things.
Well, what he's saying surely is that the question of likelihood and what it means depends ultimately on the context. It's all a question of legal policy. In some classes of case, like the asylum class of case, you have one answer. In a criminal case, you have another answer, and each type of case has its own context. Now, in Re-H, I think it's very important to my mind to bear in mind that what Re-H was about whether or not the threshold facts were established. That's what Re-H was about. Anything he says about anything else is obiter. That's what it was about. And here he is saying that these are nuanced questions, and as I understand it, you can't simply say that because it's a past fact, you necessarily have to establish it on the balance of probabilities in every circumstance. There may be hundreds of facts in relation to an analysis at the welfare stage. And is it really right that you have to prove every fact beyond on the balance of probabilities? I don't know. It may be that it's much more nuanced to that you have to look at the risks and so on. It's all a balancing matter and so on. But that's what, to my mind, he's saying here. And he's not actually saying what the answer is in paragraphs 12 and 13. You have to go on to...
No, we get it coming on at 31 and 32.
Because he then goes on in 14, 15, 16 to reiterate the analysis and the tests in Re-H. So this is only introductory stuff.
Yes.
Yeah.
There are a range of possible answers, he's saying.
The Lord's yes.
But then he comes on at the welfare stage, doesn't he, in 31, 32, to pick up what he's been saying, as I read it, I may be wrong, what he was saying in 13.
Yeah.
That seems to be the way it fits into the overall picture.
Well...
So when you come to paragraph 27, say, he's therefore, and 31, he's applying his analysis in paragraph 13.
I don't think there was any doubt about it. I thought everybody agreed you have to establish for the threshold, section 31, on the balance of probabilities, that these events occurred which put this child at risk. When you get to who the perpetrator is, if you can't make your mind up, that doesn't mean you ignore it. You're at the welfare stage. I didn't know there was any... Is anybody doubting the correctness of either of those?
No, my lords, we're not. It's how the confusion that undoubtedly has arisen in this area of the law, where it is derived from.
What is this confusion?
Well,
I'm not confused.
Can I take you to what I would respectfully suggest is the confusion, and that is the North Yorkshire County Council decision at tab 7.
Well, can you just identify what is the uncertainty? Just crystallise so that I can understand why we're looking at these cases. What is the problem we're trying to solve? As between what and what are we trying to get the answer?
The problem we're trying to solve is to identify when a judge conducts a fact-finding hearing, how one, if you like, looks at the risk factors, the likelihoods, and where one goes to if the judge determines he or she cannot find, as against A or as against B, that one is a perpetrator of injury.
I thought if the judge couldn't decide between them, everybody agreed that it was relevant that neither had been exculpated. Does anybody dispute that?
No, my lords, nobody.
Well, then what is the dispute?
The dispute is the suggestion that there have been two standards, two tests operating, and that it is because there was a second standard, a second test operating, that Her Honour Judge Kushner, QC, fell into error. So it is relevant to look at the factual.
Which were the two standards?
One standard, it's the appellant's case, is the heightened cogency on the finding of fact developed by Lord Nichols, and it is said that the use of the word likelihood in paragraph 32 is an indication that there was a heightened test. Lord Nichols had set one, because one can only look at likelihoods if there was a different test or standard running alongside the first.
And what do you say this Rio is authority for, and what do you say is its current status?
I say it's authority for only that the judge at the fact-finding hearing should, as a matter of course in evaluating whether they can identify perpetrator or not, go through all those factors, likelihoods as to whether it's parent A or likelihoods as to whether it's parent B. That if the judge does that exercise, an exercise that the judge did in this case, that is what goes forward for assessment purposes in the event the judge cannot determine which of the two is the perpetrator.
And that's applying, I think, paragraph 31.
Yes, it's paragraph 31. It's the use of the word likelihood in paragraph 32 and how that has been developed in other authorities that has led to confusion. But certainly, the local authority's position is that it is and always has been clear that the duty of the fact-finding judge and the use of likelihood by Lord Nichols did not import a different standard or a secondary standard or a different test. The test has always been one and the same, and that is balance of probabilities.
Yes. I mean, I may be just repeating something I said yesterday, but as I understand it, you're directing attention to two different stages in the process. There is the initial task of the judge, who finds facts if he can, and maybe he can't determine. But then there's the next stage, which is the welfare stage, and whatever the judge may say in the process of reasoning, I think you're saying is relevant at the welfare stage, because these are raising issues which will be to be taken into account in assessing what the ultimate disposal will be. Is that too simplified?
Well, my lords, that's right. But what I would go further and say that I can identify for your lordships where the tests that Lord Nichols, or the description Lord Nichols gave, have become a test of relative likelihood, and where the mischief, such as it exists, has arrived.
Well, I just wonder how much we need to explore all of this, because if we accept in Re B as the correct authority, and
yes,
you obviously do,
indeed,
and one can measure what the judge did against that and decide whether or not she misdirected herself.
Well, my lords, with respect, one can't look at how she directed herself and what she thought she was doing without understanding whether there was an additional gloss and indeed what she had been invited to do. It appears from the transcript, though it's by no means clear, that she was initially going to be invited to express relative likelihood from the Sheffield case, which the bar has identified is the North Yorkshire County Council case. And in North Yorkshire County Council, what Lord Nichols had said in the three separate authorities, in terms in particular to the likelihood of harm, looking at section 31, becomes relative likelihood for inclusion and exclusion from a pool of perpetrators. That is where the difficulty that arises in this case has arisen. It's set out very clearly in the head note as to what it is suggested North Yorkshire County Council, that's tab 7, Lords, is authority for. At point 2, it says, where there was insufficient evidence positively to identify the perpetrator of the injuries using the balance of probability test, the test to be applied was, is there a likelihood or real possibility that A or B or C was the perpetrator or a perpetrator of the inflicted injuries? Mm-hmm. And that is said to derive from Lord Nichols. If one goes to paragraph 21, the observation of the then President, having referred to, indeed from 14 onwards, firstly the decision in Re-H, secondly the decision in O&N, she goes on to say, although Lord Nichols of Birkenhead was focusing on
Where are you reading now?
Paragraph 21. Although Lord Nichols of Birkenhead was focusing on the welfare or disposal stage of the hearing, the passages in paragraphs 31 and 32, those are the ones Mr. Hayden contends should be struck through with a blue pencil, relate equally... Parts thereof. Relate equally directly to the task of the judge trying the first, section 31(2) part of the case. In his observations about the likelihood of future risk and the likelihood that carers were possible perpetrators of past injuries to children, he was, in my judgment, applying the same test of real possibility.
And you say he wasn't?
Yes.
And her ladyship is referring to paragraphs 12 and 13, which is set out at paragraph 19.
Yes.
Yes.
But quite clearly, that is why the language of likely, the use of likely, meaning real possibility when looking at the likely harm test, that has been added to and becomes a test of inclusion and exclusion from a pool of perpetrators. And there was no such test promulgated by Lord Hoffman in any of the decisions, nor any support for what became this particular test. And if there has then been a difficulty and the use of expressions such as relative likelihood, this is where those expressions are derived. In effect, the Court of Appeal decision permitted a judge to express, in cases, the relative likelihood for inclusion and exclusion. North Yorkshire was, of course, a case of more than 2 perpetrators. And the issue that had been identified by Mr. Justice Charles at first instance was, because he'd found that there were 4 possible perpetrators in this case, in order to exclude anybody from a pool, there has to be a no possibility test. So that was the context in which the Court of Appeal were trying to look at what does one do when one has more than 2 perpetrators in a pool. How does the judicial exercise, how the function is carried out? Because 2 of the interveners in that case, the night nanny and a grandmother, were seeking to persuade the court that they should be excluded as possible perpetrators. And the facts of the case were 2 very serious injuries. The night nanny and the grandmother could only have been perpetrators of one of the injuries because of the timing of the same. But they fell into the pool of possible perpetrators of the other injury. And they sought to persuade the court that they ought not to remain in the pool.
The distinction is what, between no possibility and no real possibility? is it?
My Lord, yes. Mr Justice Charles believed that no possibility was derived from the decision of Lord Justice Thorpe in Re B compelling evidence, which is the Re B in Re O and N and Re B.
In paragraph 26, do you say that Her Ladyship's reformulation or formulation of the test set out by Lord Nichols as is there a likelihood or real possibility that A or B or C was the perpetrator or a perpetrator of the inflicted injuries? Is that right or wrong?
No, it's wrong.
It's wrong.
It's certainly wrong that that was what Lord Nichols at any stage at all was considering in any of the decisions of the House. And it is wrong because it takes the real possibility description given by Lord Nichols to looking at a likelihood of future harm to the identification of perpetrators in the pool and to the exclusion of perpetrators from a pool.
So what is the test on the hypothesis that the finder of facts isn't able to say on the balance of probabilities that it was X or Y? What is the test that has to be applied in deciding whether the possibility that X or Y was the perpetrator for the purposes of the welfare stage?
That is the issue that has not been clearly identified.
As I'm asking you for your submission, you say this is, you say, I'm interested since I was a party, I now see this decision.
Well,
you say that paragraph 26 is wrong. How should the test have been formulated?
Can I begin by saying
Well,
this?
could you just tell me what the test should be?
The test, logically, the test, if you wish to exclude, would be no real possibility. That arises purely because we know from the facts of Lancashire and the effects of Lancashire and O&N that parents who may not have injured their children remain within a pool at the welfare stage because there is only a real possibility. In the event they were a non-injuring parent, they remain in. So in Lancashire, both parents remained in the pool.
So that would be to apply a real possibility test.
Which is what's
Yes,
there.
well, that's what is the difference.
That's what paragraph 26
Except you put it in the
I
negative.
thought you were saying that was what was wrong about paragraph 26.
What's your proposition of what the law now is on this point?
My proposition on the law is that none of the decisions of the House have looked at the issue and the test that was promulgated in North Yorkshire. So on the law at the moment, North Yorkshire is the legal test that has been identified, but that cannot be right.
No, please, strip out all the jargon and names of cases. What is the test?
For exclusion, there isn't one.
Well, are we talking about exclusion? That's the issue.
Well, when we go to look at Her Honour Judge Kushner's decision-making, quite clearly those issues of exculpation and relative likelihood are all, various different times, matters that were put to the judge. The reality is that the court has, on the balance of probabilities, to decide whether it was A or B, looking at the evidence as against A and the evidence as against B. If it can't determine A or B, you don't talk about exculpation. It's axiomatic. It's the opposite side of a coin. If you cannot determine perpetration as against A or B, the other parent cannot be exculpated. The difficulty arises where you have more than two.
The difficulty arises when what?
You have more than two in your pool. Because it may be, as in the Lancashire case itself, that three perpetrators remain in a pool. But it may also be that the pool, the factual matrix that led to considering whether it was A, B, C, D, E, F or G who injured the child, has not resulted in clarity in terms of A, B, C, F and G.
Well, supposing that a child has been injured in a house in which there are 5, let's say, adults.
Yes.
Now, if one is deciding whether or not all 5 adults are in the pool, to use that phrase, is there anything wrong with saying, well, I'll only include people in respect of whom I consider there's a real possibility that they were a perpetrator, and I exclude somebody, let's say, who is disabled and could not have possibly have inflicted the injury?
The difficulty arises in that you are potentially involving tests which are unnecessary and make clarity and make it less clear.
Why? Why is it less clear? I mean, I'm deciding which of these. I'm deciding if I really consider that all 5 people in this house are members of the pool, as you call it. Why is using a test of real possibility making it unclear?
But, my lords, you do not approach that by including people in the pool. They are included because of the factual matrix. It's not necessary to have any legal test that puts people in the pool.
Are all 5, including the disabled person in the household, all 5 automatically in the pool?
My lord, that will arise in a circumstance where the time window for injury to a child, all 5 of them
Let's
have a
assume
care.
that the time window is satisfied, all that sort of thing. We assume all that.
Well, my lord, it's only when you go through your fact-finding exercise that you can actually
We're talking about questions of law here. That's what we're trying to get, a legal test. Is there no legal test on this earth which will include or exclude somebody from a pool if you five people in a house?
There is the test that is set out and identified in North Yorkshire. There isn't a test anywhere else for
Is
inclusion.
it right or
and
wrong?
exclusion.
We're asking for your test.
Well, my lord, the difficulty is that if it's the right test, it introduces the issue of relative likelihood and of a judge expressing relative likelihood. I have no difficulty in a pool of 2+ for a no real possibility test as identified in North Yorkshire.
But why does it involve introducing?
I don't understand why
I really don't. I mean, we're positing a situation that a child has suffered harm. We're positing a situation that more than one person might be responsible for it. We are positing a situation where the judge is unable to conclude, as against any of the candidates, that on the balance of probabilities they did it.
Yes.
So, to the extent that it is necessary to have this pool, which it may or may not be, it's going to depend upon how you make predictions for the future and what you think is going to be best for this child. Why do you need to have any test other than that these people, there is a real possibility that any of these people did it? Why do you need to do anything else?
Well, there might not be a real possibility. The question is, if there is no real possibility, the question is, do you exclude people from the pool on the ground that there's no real possibility that they did it?
Sorry, I'm saying exactly the same thing as you're saying.
Well, it doesn't sound like
And my lords, certainly.
I'm sticking up for paragraph 26. It seems pretty clear to me.
Well, my lords, as I set out in the local authority case, we would agree that to arrive at a test of no real possibility is an appropriate test to exclude from a pool of adults. That arises by the logic of the decisions of the House in the 3 cases we have looked at.
What about the other way round? That to be included in the pool, there has to be a real possibility.
Well, there is nothing...
That shouldn't be a difference, but...
There shouldn't be a difference.
It's a different way of putting it.
It is, but it is because of that that judges appear to talk about, rather than can I identify a perpetrator, can I exclude a parent? So I use it only as an example to then deconstruct the fact-finding exercise that was conducted within this appeal. Have no difficulty that it can be a test. It ought to be a test that is clear in that it is a policy test that applies to inclusion and exclusion. It has arisen, as I've said, incorrectly from an incorrect observation of Lord Nichols.
Why does the number matter? I mean, obviously, you've got to be more than one. But does it make any difference if you have 2 or 5 to the test? I can't see myself why the test should be different.
Well, Well, Lord, therein lies the heart of this particular appeal, and the possibility one then has two separate tests, and it is that, my respectful submission, rather than as the appellant contends.
Well, I don't really understand that. Is it because this particular case was one involving more than two? There's one test set out in paragraph 26, and you say you shouldn't apply that in a case where there are two? I mean, take Lord Rogers' example. You have only two, the two parents, let's say. One of them is so severely disabled. They're both in the house. I mean, why should it be any different from the example he gave you where you have five and one of them is severely disabled?
There isn't a difficulty. There isn't a difficulty of having real possibility for inclusion, no real possibility for exclusion. It, however, cannot be the way in which a judge approaches the exercise if there are only two. Lord, if I can...
Sorry, if there are only two and one's disabled and couldn't do it, then on a balance of probabilities, it wouldn't be very difficult to find that the other one did it.
Well, my Lord, yes, that's not. So there isn't an exclusion. That's the point that I am trying to make. That if you've only got two, you're looking for the perpetrator. If you can identify A as the perpetrator, that is the end of the exercise in terms of you do not need to go any further. You have identified the perpetrator.
I see myself, I'm far from satisfied that's the case.
What happens if you find on the balance of probabilities, as between two perfectly able-bodied husband and wife, balance of probabilities it's husband, but you only find it on a, so to speak, a narrow balance of probabilities? Have you got to ignore totally the real possibility that you're wrong and that it was wife after all?
Well,
I mean, there's a simple answer, yes or no to the question.
You do not ignore the fact-finding exercise and how the judge has arrived at that decision to say that X is the perpetrator. The risk factors that will have been identified that are relevant at the welfare stage will go forward, including, of course, the identity. One can have, for example, a case where father is addicted to crack cocaine, leaving mother isolated. He spends most of his time associated with criminal activity to fund, and mother is isolated.
And does the question change then as you go forward?
Well, of course it does. What might happen in that situation is that the fact-finding judge, having received evidence that father's character changes when he takes drugs, that he becomes aggressive and so on, will feel able to say that the injury was perpetrated by the father. But running alongside that, one may have a second set of facts, that is that the mother was increasingly isolated because of the father's behaviour. She was seen to be overwhelmed and overburdened. If the injury is a classic loss of control injury, which one sees in these cases time after time, a fractured leg by yanking and pulling a child roughly, the judge may have gone on, as I've said, and decided that the characteristics and the effect of taking crack cocaine on the father would have led to the injury. But the fact that the mother was in a position where she might have caused injury to the child because of her isolation, because of her increasing inability to cope alone with the child, is a factor that goes through at the welfare stage. So that all identification of risk factors and issues as against parents in the fact-finding exercise are relevant to the welfare stage.
What's therefore the point of finding on the balance of probabilities in fairly even cases? Because all the factors will have to be taken into account again.
Well, that's where concern must arise.
Sorry, I missed
That's where concern must arise. That's the concern that we see Lord Justice Thorpe has in the Court of Appeal in this case, when he asked Mr. Hayden, what happens if it's 51%, 49%? The reality is, it's the Lancashire case all over again, but in a different formulation. If you were to go through to the assessment stage, with the assessors not having a clue that it was 51%, 49%, not knowing that in fact the risk factors, which were different, qualitatively different for mother and father, had only just been tipped one way rather than another, that would be wrong. It would be a sweeping departure from the protectionist stance taken, highlighted perhaps best in the Lancashire and A. So that is a difficulty.
The statute is not driving a judge who has genuine problem in saying which of the two, let's say it's two, which of them is. It's not a test which the statute actually requires to be satisfied,
No,
is
it isn't. It is
so
there.
the judge goes through, he's satisfied as to A, he's satisfied as to B, and he can say that despite the difficulty he has in sorting out which of the two actually did it. And he's got his list of factors which he sets out in the judgment, which you say, all of which, if they're risk factors, are to be taken into account at the welfare stage.
Yes.
So are we struggling to find an answer to a problem that doesn't really have to be addressed?
Well, my lord, the local authorities case is quite clearly set out that we are struggling against a problem that will not exist, in the sense that all those factors go forward into the welfare and assessment stage. Those
So,
factors are
I'd just like to be quite clear what you actually mean by that. If you take my lord's example of the fact finder who says, the question for me to consider is, in each case, in the case of the father, was he, on the balance of probabilities, responsible for the injury? And the judge says, well, on the balance of probabilities, I think he was. But it's a narrow decision. I can't be sure he was, and I don't wish to put a precise percentage on it because that may not be desirable, but there are serious questions about whether it might have been the wife, yes, the mother. Now, at the welfare stage, is it a relevant factor for the welfare judge to consider that there was a real risk that it was the mother who caused the injuries? Is that a relevant or an irrelevant factor?
It must be relevant, and indeed in
Now, is there any authority for the proposition that it is either relevant or indeed irrelevant?
Well, no, not when it's
so
formulated in that way.
There's no case which determines that question one way or the other. Is that right?
It is right.
So it's open, that question.
It is.
There's nothing in Re B or Re H or any of the cases which grapples with that question.
No.
The problem is perhaps that many of the cases proceed on the hypothesis, and the cases we've now been looking at, all proceed on the hypothesis that the judge was, at the first stage, was unable to say who was the perpetrator. And there's now quite a lot of jurisprudence about what happens in those cases. And that's what this case we're just looking at is.
Yes.
We can see how that... but the fact that that has been treated as one class of case might suggest that the risk that the mother did it, or may have done it, is irrelevant at the fact-finding stage. Because otherwise, why would you start with that hypothesis? Why would you say that these principles only apply in a case where the judge is unable to decide the first question on the balance of probabilities? So it might be said that the unspoken assumption in the cases is that the answer would be different in the case where the father or X is found to have done it. Obviously, it all depends upon the facts, doesn't it? If it's a case of some critical injury, like, I know, breaking the child's leg, it's pretty obvious that once you've discovered who it was, that person did it and the other person didn't do it. But it may not be so simple as that.
Yeah. In this case, you say this is an uncertain perpetrator case.
Yes, Lord.
But on your case, what difference would it make if that 60-40 had to be treated as a finding?
Well, as I already outlined yesterday, it makes no difference in this case at all. The drive to identify a perpetrator is a child protection friendly drive, because it's better for a child if they have been injured to know the circumstances in which they have been injured, and where possible to identify, if it's mother or father, whether it was mother or father.
But surely it goes much, much further than that. If one's thinking about these cases as real cases, it must make a difference to how you plan for a child's future if you are planning on the basis that the only potential parental care of this child is somebody who has injured the child and has all these vulnerabilities on top, and a situation in which you're planning for the future of the child on the basis that that person either did not do that, but has all those vulnerabilities, because you would do different things. Or you might.
Well, yes, those are the risk factors in the fact-finding exercise that the judge tries to pick out and identify that run against all the possible perpetrators. And where there is clear evidence, as there is in many cases, of perpetrator, and the judge makes that decision, that analysis of how the decision was arrived at and the particular risk factors in a case go forward to the assessment stage.
Yes, but how can you do that on the basis that the mother didn't do it when its common sense says she may well have done it, but on the balance of probabilities the father did it?
My Lords, I do not say that at the welfare stage the assessors are excluded from the judge's balancing and consideration in the event that the judge has identified a perpetrator. How the judge identifies the perpetrator is an important way of balancing and looking at those risk factors that apply or seemingly apply at that stage, because of course matters can change. Further in-depth analysis can reveal far more serious and problems as against both parents. But my lords, for most judges, I would venture to suggest, conducting the fact-finding hearing, that the cases that appear before them are fairly clear that they're going to be able to identify the perpetrator, or they get to a decision because of all the factors of denials, of failure to cooperate, of multiple risk factors that run against both parents, where the judge cannot reach a decision. If the judge has been able to drive a clear path through and say this is a case where the father perpetrated X, Y, Z injury, that finding clearly is relevant to the welfare stage. How the mother has responded to that finding in the event she would not have been on notice, and as often can be the case, there are no other adverse factors attributable to the mother. Good upbringing, proper concern for the child's welfare, horror at the notion that her child has been injured, desperately trying, and we cannot, Lords, in my respect to the Commission, duck the fact that if you are a non-perpetrating, caring parent, you would want the child to have occasioned injury by either accident or by some organic reason, rather than think that the person who you are in partnership with has injured that child. Yeah.
Especially if it's the other parent of the child.
Especially if it is the other parent of that child. That would be a normal, natural reaction. But when it becomes, and it is clear, because the fact-finding exercise on whether the harm is non-accidental or not has been proved, the non-perpetrating parent, who has been identified as non-perpetrating, her responses to that fact-finding process become critical. If, for example, she says, I still cannot believe, I will never believe that my partner has perpetrated these injuries, I stand by my man, then for any assessment purposes, the risks of returning the children to the mother will be unmanageable, indeed not even calculable, because the risks will be unaltered from the risk that pertained that led to injury of a child. But as here, there are those cases where there are different types of risk factors that run with both parents, and when a careful analysis of those risk factors may reveal a hesitate to use the word propensity, but it's a bit of like the elephant in the room. Because if you were looking at a man's past character as to whether or not he has convictions for violence or whether he's got this, that and the other, if that factor becomes relevant, and it may become very relevant, if children have been injured in the past because of domestic altercations with a partner, then of course that becomes a relevant or a likelihood that in the crossfire, subject to how the child was injured, the father could be the perpetrator. All of those factors become relevant.
Well, we've had a very extensive discussion of the various possibilities. Where do we go to now? There are other cases we need to see. I mean, you've looked at the Yorkshire case.
No, my lords. I agree that Lord Justice Wool's observations in Re M following Re B are appropriate. If you find that X is a perpetrator, X is a perpetrator. I have no difficulty with that. So far as Lord Justice Thorpe in Re A is concerned, the language used by Lord Justice Thorpe on the evidence, more probable that it was the mother, is the language of fact-finding on the balance of probabilities, having weighed the evidence, and therefore it is likewise a finding of fact.
Yes.
That's not this case, and if we go to the facts of this case, can I begin with, obviously, the fact-finding hearing?
So we're going back to the appendix, part 1.
Well, I was just going to ask you to look at page 52, the first paragraph, and to say yes or no, is that a right approach? The suggestion is that the judge was wrongly applying the heightened cogency test. Do you agree or disagree with that proposition?
I do not disagree that how that test is written down suggests the formulation, balance of probabilities, but when you're looking at the evidence, you look at reliability and cogency equivalent to the gravity of the allegations. I don't accept that a heightened cogency test is something that judges have routinely used, Lord Justice Thorpe being the notable exception. Lords, this particular fact-finding judge appeared in Re H and others. She was leading counsel for the children. She was part and parcel of considering both as an advocate on the issues for their lordships to determine what test is to be applied, balance of probabilities or something else.
I'm not quite sure what the answer is to Nora's question.
Well, I accept that formulation appears to suggest that it is a heightened cogency test, if one accepts that such a heightened cogency test is in fact something that is derived from Re H and others and has been applied by judges.
Well, we can see what she says, and it looks as though she is applying a heightened cogency
my lord,
test.
yes, it looks like she may be, although it is somewhat difficult to reconcile how this particular judge would be directing herself on a heightened cogency standard in light of the fact that she was, as I've already said.
So you're saying you're doubting whether she really
Yes,
was following what she seems to indicate in what she says?
My lords, yes, I think it became a mantra that was set down whenever by many judges, but that what she did in reality was no more a heightened cogency test. And may I say this, that Mr. Hayden indicated that the points that were raised, that this was a test that was then applied to identification of perpetrator by the judge, was a matter that was before the Court of Appeal. It was not. Because if one turns firstly to page 53 and looks at the questions, identified by Her Honour She says, if NAI at point 2, can the perpetrator of the injuries be identified? At point 3, even if perpetrator cannot be identified, can either of the parents be excluded as a perpetrator? The reason I spent time in Yorkshire is the potential for that secondary consideration, when you only have 2 parents, to have caused confusion and nothing more. But my Lord, if you turn to page 57, after finding that this child had suffered injuries, page 56, on page 57, she identifies, although it is possible that both parents have injured Jake, this is less likely than that Jake was injured by one of his parents. I therefore look at each parent in turn. That is a perfectly appropriate direction to herself. That is not a heightened cogency argument for the determination of perpetrator. In fact, that is how Lord Hoffman himself, in paragraph 15 of Re B, expresses what happens once you have determined that a child has been injured non-accidentally. When you've only got 2 people, the only question that arises is whether it's more likely than not that it is A rather than B. And that was the issue that Her Honour was considering. In doing that, she sets out at pages 57 through to page 60, all the considerations, whether they were findings of fact, whether they were observations, all the information that she had before her in respect of the father and the mother. That is what we would suggest on behalf of the local authority, is what Lord Nichols in paragraph 32 was saying the judge does at the fact-finding hearing, looks at these things.
And she, at page 39, she explains after Re B what she was doing.
Yes. Sorry, page
39.
39.
39.
Yes, my lord, she does, but in actual fact, she explains earlier than that. The suggestion has been that what Her Honour did, following the decision being handed down in Re B, was to go back on her adjunct to judgment and reconfigure the test that she applied and the manner in which she approached the decision-making. But if one goes to page 61, which is the adjunct, prepared 2 days after the exchanges between counsel for the mother and Her Honour on the 4th of June, paragraph 2, the judge expressly states, I've already said in my previous judgment that neither parent could be excluded and gave my reasons for this. The reason why, again, I talked about inclusion and exclusion and the difficulty in language is, of course, because of the suggestion that the judge may have been looking at exclusion rather than perpetration. In reality, when you have to, it's one and the same thing. But it is the language that sometimes causes difficulties, and in this case may have caused difficulties in terms of the interpretation of what the judge did or did not do. She then went on at paragraph 3 to say the parties feel that any assistance in the relative likelihood of each of the parents being the actual perpetrator would assist those assessing the mother. It's fair to say at page 10 of her exchanges with counsel for the mother, Mr. Rowley, she actually doubted whether her expression of 60-40 would help the assessors much in that particular case. But that was the invitation to the judge based on the test set out in North Yorkshire County Council.
I mean, if the position is that even if you do find on the balance of probabilities it's A, you can and should still, at the welfare stage, have regard to the real likelihood that in fact, after all, it was B. If that's the position, well then I'm not altogether clear why it's necessary in the first place to reach any decision on the balance of probabilities. Why isn't the most helpful thing to do simply to say, there is a real likelihood that it's both, but actually I think, and it would be, it seems to me, positively helpful to give some indication, statistical or otherwise, that nevertheless, although there's a real likelihood, that a real possibility that it was A, it's that much more likely that it was B.
Well, my lords, in those cases where the exercise does not really throw up much by way of difference between the parents, that must be right. The benefit of identifying a perpetrator is in those cases where it can have the effect of making a significant difference on the welfare stage and the assessment and analysis.
Yes.
I've already mentioned the position where there is a clear route through. All evidence points to the mother, and the mother is identified as a perpetrator. That gives father the opportunity to separate if it's necessary, and of course that might not in fact be necessary. If one identifies particular stresses and factors applying at the time, and everyone is open about those stresses and factors, and the parents can work in order to alleviate those stresses and factors, in actual fact children go home, and children do routinely go home to their parents even after findings have been made and perpetrators identified in a range of injuries, some of them quite serious.
You're really emphasising that one or other of the parents actually would be wanting this issue to be addressed and a finding made in his or her interest.
It is, because in the case where the court can decide, it can be an opportunity for the parents, for everybody in the case, to move on. There are many reasons why parents won't cooperate at that stage. Fear of prosecution and a prison sentence is one in terms of the more serious injuries, or indeed in any injury to a child. Many, many reasons. But the benefit of clear identification, and I say clear identification of a perpetrator, is that
What do you mean by clear identification?
Well, my lords, what I mean is being able to identify a perpetrator when there are no other real risk factors that run against the other person. So in a case...
You're talking about proof beyond reasonable doubt.
No, my lords...
I think actually we can see this line of thought at page 39, where the judge is trying to explain what she sees as the difference. She's saying that what she's talking about is the percentage likelihood is, as she say, qualitatively distinct and different from findings on the basis of evidence to establish on the balance of probability whether a fact is proved against one or other parent.
Yes,
is that not it? And you're saying, well, one of the parents may actually want that finding in his or her favour if it can be made. But then the problem arises, of course, in a case like this where the uncertain perpetrator situation presents itself, and then there are questions as to how much further the judge should go.
Yes,
and she's explaining there that there is this qualitatively different process which has a bearing on the welfare stage.
My lords, yes. It's why we begin our argument supporting the observations of Lord Justice Wall in Reed E. Straining to identify the perpetrator, any suggestion that what Lord Hoffman's binary approach in paragraph 2 comes into the approach in paragraph 15 and requires a judge to determine is as harmful, potentially for children, as excluding parents when you cannot identify who the perpetrator is.
So what's the difference between an identification and a clear identification?
Well, my lord, it's normally something that happens as a matter of fact and not by any application. Those are those cases. There are cases where there is a clear route through, always has been a clear route through, and the judge makes that decision and identifies the perpetrator. By far more common in cases and the difficulties that arise are cases like this, where there are risk factors attaching to both parents. The benefit of making a finding is that people can then respond to the finding.
Supposing that the judge thinks on the balance of probabilities it's the father rather than the mother. In another case, it's clear beyond a peradventure that it's the father rather than the mother. Does the judge have a choice? I mean, do you say, well, and it's a clear beyond peradventure, then the judge will decide that matter and point to father. Where it's a bit not so sure, but it's on balance it's father rather than mother. Do you say that the judge says can choose whether to make a decision or not?
My Lord, what I say is this, that if the judge is uncertain, the judge shouldn't make a decision, because it shouldn't have to choose.
Certain, because the standard of proof is not certainty. He can be uncertain, but politely on the balance of probabilities, he thinks it's one rather than the other. The question is, does he have a choice, the judge in that situation, as to whether to make a finding of fact?
Well, my Lord, the judge applying the test to his fact-finding exercise will look at those factors. What the local authority says that there are cases where he will not be able to, and he should not be, on one interpretation of Lord Hoffman's paragraph 2 and 15, the one that was being suggested to Her Honour Judge Kushner, that she so roundly said no, should not be that the judge has to find as between the two, even though, of course, when there are only two, and it's clear there is only one perpetrator, as here, the judge...
Actually, that's very interesting, what you've just said, because the judge found on the balance of probabilities that there was only one perpetrator, as I understand it. And
yes.
Looking at the facts, that seems likely. So she did that, but she wasn't able to find on the balance of probabilities who it was. I find it ironic that she was able to make one finding, which is a very important finding, but not able to make the second one. The difficult question, which we're all struggling is, what's the consequences if she does? That's what we're all struggling with. Or if she doesn't.
My Lords, I've already indicated, if she had have made a finding 60-40 and thought herself able to do that on the evidence, in this particular case, given the risk factors that run with this mother, it wouldn't have made any difference at all.
Well, the risk factors, of course, are going to have a very considerable influence on the extent to which the judge can decide as between the two possible perpetrators.
Of course.
Is that not right? I mean, you could have a case where, really, as far as one is concerned, there really are almost no risk factors, and it's hard to see how, in that situation, if there are no risk factors, how there's going to be any problem left, because the factors are all the other way. But
yes.
The risk factors can't really be detached from the process of reasoning that leads you to the finding, if you can make it.
Hence the exhortation to judges at fact-finding hearings to express the likelihoods of it being one rather than another during the fact-finding process.
Yeah. When you talked before about one of the reasons for identifying the perpetrator was to allow the parents to move on, you're turning the judge into part of the social team. And in those circumstances, it doesn't help anybody for the judge to find on the bare balance of probabilities that one or other was the perpetrator.
No.
My Lord.
Well, we can all think of cases where actually it does.
Yes. That's one of the difficulties.
I can think of cases in my past where it did help.
But Lord Nichols was saying that he's very worried about that, because it may lead you to a position where actually that's quite wrong, because there are factors which remain in the air. And if you were to put a Lord Hoffman 0, treated as strictly either 1 or 0, that would be very dangerous.
Well, that's why I was saying that the difficulty for all of us is what is the consequence at the next stage, whether you do or you don't. It may be that the consequence is the same, or it may be that there's a stark difference. It's rather hard to imagine that it could be a stark difference. You make your finding on a balance of probabilities and then completely leave out of account the possibility, the real possibility, that you may be wrong. That's, I think, the problem that we're all struggling with. And it's not the real world either.
No, my lords, it isn't the real world. And if we begin again, first of all, a judge is not required by any reason of law to make that decision as between the two in satisfaction of the threshold.
But if the facts are, if he concludes or she concludes on the evidence that it is more likely than not that it was A, surely it is the duty of the judge to say so. What the knock-on effect of that is the next question. Maybe on the facts of the particular case is the next question.
Yes.
You don't have to strain to do so because it may not be possible, and one should recognise that. Perhaps in lots of cases it's not possible. But surely it is the duty of the judge as a judicial figure to decide that question if he or she can.
If
he or she can't, then obviously they have to say they can't.
My lords, yes.
And that's Lord Justice Wall, isn't
he
it?
did, indeed.
But if he does, if the judge is able to say that on the balance of probability it was X, obviously there are various possible bases upon which that conclusion could have been reached. One is that it's plain as a pikestaff that it was X, and there's no real possibility that it could have been anybody else, in which case it would obviously be better if the judge said that, so that next time round the judge wouldn't trouble with the other person. But if, on the other hand, it's a more nuanced affair, surely some sort of indication of where the balance lay would be desirable. And as I understand, it's your submission that at the next stage, it is relevant in that case for the welfare judge to consider the position of the, quotes, innocent, unquote, party, and whether there's a risk of that person having actually been the perpetrator after all. And then how that happens, how it's taken into account, all depends upon the myriad factors which the welfare judge would take into consideration. Now, is that the right approach?
With respect, yes, that is how the local authorities...
Now, none of the cases have put it quite like that so far. Maybe they should.
Well, again, the reason why they haven't, in my respectful submission, is because of the use of language, which has led us into relative...
part of the trouble is there's this question of the two-stage process is part of the trouble, perhaps, because there's talk about the fact-finding judge and the welfare judge. Actually, there is a threshold stage which it raises questions which we've seen in the authorities where there's no doubt what the approach is. And then everything else, once the threshold is passed, is, on proper analysis, part of the welfare stage. Though, of course, it may consider a consideration, an analysis, and perhaps decisions about the facts. Surely that is the correct approach. And in the case of we were looking at before, the paragraph 26 case, all this talk about who's in the pool is partly because you have the two stages. At the first stage, it may be helpful to know who's in the pool before you go on to the next stage, because it's important to know, for example, whether the grandmother should be represented on the next stage or not, and those sort of questions. As I recall, that was one of the problems in whatever the case was called. So,
Yorkshire.
Yorkshire, yeah. But we should be careful not to be bedeviled by these two stages.
Yes.
No, my lord, I think the real difficulty is the way in which different considerations at the welfare stage and the way in which one identifies what should be considered at the welfare stage, which are the risk factors, right. How you express that.
It does seem to me that we are getting very bedeviled, as my lord has said, by the distinction between fact-finding and welfare. Facts have to be found at any stage in these proceedings, or not, as the case may be. You know, is mum a drinker? Is dad a drug user? These things are often relevant but uncertain. The fact that we have adopted a practice in some cases of hiving off certain factual issues to be decided in advance shouldn't blind us to the fact that it's an overall picture. Is the threshold crossed? What's best for the kid if it is?
Yes.
And it's all one case. It was never intended that it should be split off into two, a threshold and a disposal stage. Fact-finding is not necessarily just a threshold thing. Sometimes it's there to find what happened to this child and possibly who did it or other things. But we ought to approach this whole thing on the basis of one judge dealing with one case, either at a combined hearing, as this should have been, or at a separated hearing, but looking at the whole thing holistically, making such findings of fact as are essential to be able to make the order, making such findings of fact as can be made in order to help make the order, looking at the other things in the background and making an overall evaluation. And if we get too hung up on these differences, I think we're going to make problems for ourselves which are not necessary.
I think that is, with respect.
I mean, is it really just the one? Because I thought that the threshold, there's a case which says, I'm satisfied on the balance of probabilities that this child has been emotionally abused. I'm not satisfied on the balance of probabilities, but reading between the lines, there's a real possibility he was sexually abused too. And I thought that the authority was clear. Having not got the sexual abuse through the threshold stage, you simply ignored it entirely as a possibility from then on.
That's right. Well, that is right, but that doesn't mean to say that it's not two issues in one case. It's all one case.
It still matters that the judge finds as a fact within that fact-finding exercise. If the judge has found as a fact in the example given of the drug-taking father and the isolated mother, those isolation factors, but that the father perpetrated, it's those isolation factors that go forward in terms of looking at the risks that have been identified. If, however, at a fact-finding hearing, as indeed is, I think was the point in Re-H and a judge could find only emotional abuse, but could not find sexual harm proved, that is the end of the consideration. There are many cases where allegations of sexual harm are alleged but cannot be proved, but there are many other aspects of risk and likelihood of harm which do satisfy the criteria.
We're just going to the section, which we seem to have lost sight of.
Yes.
And going just to 31.2, and just taking the example of a claim of sexual abuse which is not proved. In those circumstances, the court won't be satisfied that in that respect the child suffered significant harm. But it doesn't rule out using some of that material, does it, for the court to be satisfied that it's likely to suffer that harm?
Well, it rules out the fact that they have suffered sexual harm if, in a case, there are allegations of sexual harm which aren't proved because they have arisen, for the sake of argument, because there is a culture of allegation within the family.
Oh, yes.
Which is, in fact...
To take an obvious example.
To take an obvious example, because it is the position, as I understand the facts in Re B, in that case, there had been previous allegations of abuse.
Yes.
When the family fell out, the allegation would arise.
Well, that's a case where it's clearly not proved.
It's clearly not proved, indeed. Everybody understands that. But children being brought up in a climate of constant allegation, cross-allegation, counter-allegation, perhaps false belief that they've been abused, which is inculcated in them, that, in fact, even though you could never prove sexual harm, actually becomes a condition to satisfy harm and, indeed, likelihood of harm. because the climate in which they live actually is harmful to them.
But it's a different sort of harm.
It is, but
Absolutely different.
that's because harm is open-ended in the subsection.
Yes, and clearly, if you cannot find sexual harm proved on the balance of probabilities, it has not happened. That itself is not a risk factor to be weighed in. What might be is how those allegations have arisen if there are other factors at the welfare stage that needs to be considered.
But the reason why it's not a relevant factor to be weighed in is because of the House of Lords construction of the section.
Yes,
whatever the case was.
That's the re-age.
That's re-age.
Yeah.
That was the issue in re-age.
It was the issue.
And indeed the issue in re-B, though it was set up
I mean, one could have
as
reached
a
a
real
different conclusion, but
possibility.
that is what was held to be the construction of the statute, and nobody says that wasn't right.
No, no.
No. We've lived with it for however long.
Yes. What was said, of course, in re-B was that there was a heightened cogency test which bedeviled judges who were not able to find harm proved in the context of the sexual harm where your perpetrator is in fact identified normally within the allegation of sexual harm.
Could I just ask you about the judge's test and how it fits in with Lord Hoffman's analysis?
Yes.
Because it might be that something could be said in defence of the judge. If one looks at the test that she has identified and then looks at the way Lord Hoffman put it, you have to bear in mind, of course, that she didn't have Lord Hoffman's
So we're
judgment.
looking at page 52.
And looking at page 52, yes, just because it seems to me quite an important point in the case as a whole. If we look at Lord Hoffman's analysis, well, first of all, he has the fact in issue point, and he wasn't considering whether or not the fact in issue, namely did F do it, was a relevant fact in issue, because he was considering the threshold question. But at any rate, whatever he was considering, when he then discusses the oddities of the law, top of his list is undoubtedly beta and beta. But then he refers to the well-known cases and so on. And then he says in paragraph 14, he has the piece from Lord Nichols, I think it was after his analysis of Hornell and Neuberger, where he says, the court will have in mind as a factor to whatever extent is appropriate in the particular case, italicized, that the more serious the allegation, the less likely it is that the event occurred, and hence the stronger should be the evidence before the court concludes that the allegation is established on the balance of probability. And quite where we're left in the future as to whether we should be looking at Hornell in those cases, perhaps we're not anymore. We just look at, certainly we ought just to be looking at this case, otherwise we'll never get to the end of it. But if one compares that, what he says in paragraph 14, with what the judge says, is it so very different? Judge says at page 52. He says the standard of proof she applies is on the balance of probability, and then he says he has those two further sentences. Well, if they're just sort of further better particulars on the facts of the particular case in relation to the approach, well, how is that so different from what Lord Hoffman is saying?
My answer to that question is it isn't, in fact, any different. That this particular judge would have known better than most judges that there wasn't a heightened cogency test, that is a separate standard, and that what it became was simply a description that one shouldn't go off on a fact-finding hearing and even on the balance of probabilities simply take suspicions, whatever the case may be. It had to be determined on evidence. I was going to take your lordships to the evidence of facts in re-H&R, but on balance, what is said there seems so obviously common sense, it's not necessary to do that. But one of the difficulties is that the judge exhorted in H&R to look at the facts, and the only issue for the fact-finding judge is whether information has relevance and that fact can be determined.
Before you go to H&R, could I suggest that there is a difference between the formulation of Lord Hoffman and the way that the judge has expressed it here. Because what Lord Hoffman is surely saying is that common sense requires you to have regard to the fact, or to the existence of inherent probabilities. What he is emphatically not saying is that the standard of proof needs to be adjusted in accordance with the gravity of the allegations. Yet what the judge in this case is saying, when I apply the appropriate standard of proof, it has to be based on evidence of reliability and cogency equivalent to the gravity of the allegations. That's not what Lord Hoffman said.
No, my lords, I accept that entirely. But it is, of course, the formulation of how one weighs evidence that Lord Nichols began with, that he then went on and developed.
I rather thought that you were agreeing with the suggestion that there wasn't any difference between what the judge in this case had done and the formulation of Lord Hoffman.
Well,
No, it's Lord Nichols.
yes, but I may be interjecting too quickly, but I understood you to say earlier that we shouldn't pay too much attention to what she actually said, because that was just a mantra which she felt she had to put out.
Oh, yes. Well,
and that what she actually did, because she was astute enough to know the reality of the thing, was to do what Lord Hoffman is really suggesting. Is that a fair answer to the first question?
Well, I don't think it's one that I would regard as complete, but it may be fair.
So that's a different point. That says that the test she stated was wrong, but the test she applied was correct.
Well, my lords, what I would say is that formulation as it's set out was common and commonly seen. Certainly in my experience, it didn't actually result in the application of heightened cogency tests. But we needn't, in fact, in order to support the ultimate decision Her Honour Judge Kushner made, actually look at that, because the point that is suggested and was suggested by Mr. Hayden is that when she came to identification of perpetrator, she used a heightened cogency test. She didn't.
But we ourselves need to focus on what the test actually is and whether that test is correct or not. Because anything we say will be taken down to be given in evidence against us later.
Indeed. The test, my lords, is simple balance of probabilities. That much is accepted, that's what rate.
So judges should simply say the test is the balance of probabilities, and the judge should have regard to all the circumstances of the case.
Yes.
And then get on with the circumstances of the case.
Yes.
Well, that's a very neat point for me to ask you.
There is a very good formulation of the same propositions by Lord Brown in a case which was decided almost at the same moment as Ray B, but of course it wasn't a family case, so I don't suppose it would be cited here, but it actually puts the point very clearly as well, so it might be worth just having a look at it. I can't remember, maybe Lord Brown would remember it.
It was, I think, handed down probably the very same day.
It was, yeah.
And it's in the weekly law reports.
Is he called Donaldson?
So there it is. If you look and see when Ben B was handed down, you'll find when this
Did it have an L in its name somewhere?
Well, has there not been a more recent case?
It was appealed actually from Northern Ireland.
Oh.
Right?
Yes.
L or something.
And I think there's been a more recent case in which the House of Lords considered.
I've got a note of it. D.
D.
And actually, yes. D.
It's just called D. It doesn't have a full
Henry
name.
D. And
Also, I think I'm right to think there may be at least one more recent case, which was an appeal from a case I was involved in, where we were criticised for I think, including some sort of flexibility into the test in a mental health case, or mental health tribunal type case.
no, I think D considered that
maybe
case.
that is the case.
That's right. Was that the one that Lord Justice Richards
gave the judgment.
No,
Yes,
that is in the judgment in D. We considered, and indeed I dealt with and criticised a passage in that mental health case, which I think was called N.
That's right.
Well, it's a bit difficult
That's
for
a
you
long
to
time ago.
participate in this conversation. I mean, we will have a chance to discuss all this, of course, later amongst ourselves. But I'm wondering whether there's more that you can help us with before we invite Miss Judd to address us. But I don't want to hurry you. If there are more points you'd like to make,
No,
please
Lords,
do.
there is only one further point I'd like to make on the fact-finding judgment.
Yes.
Having, as I've already indicated, that the judge directed herself properly, as per Lord Hoffman, paragraph 15, on identification of perpetrator. And that is the factors the judge weighed in the balance when she considered her adjunct to judgment.
So we're moving to page 61.
Page 61,
Yes.
Lords.
Yeah.
At point 6 of her adjunct, Her Honour said, as recently as April 2007, namely 2 months prior to Jay's injuries, there was a referral to social services as a result of facial bruises to the father's son, then just 2 years old, following his return from contact with the father. The materials before Her Honour were to the effect that, yes, the 2-year-old son had 2 marks on his face. They were not considered to be non-accidental injuries by the hospital, and it was nothing more than what that child's mother said, that it happened when he was on contact with his father. Of course, the mother's evidence in this particular case was that contact had ceased in January of 2007, so it was simply one of those things where whether the father did or did not see that child on the relevant weekend was something the judge was not able to determine as a matter of fact. The judge didn't, and couldn't indeed, on the evidence that was before her, make a factual determination of prior harm to a child. Indeed, D child was not in any way harmed. That was the balance of the evidence that was put before Her Honour. But that's something that she is weighing in the balance when she's looking at this issue of relative likelihood. And that is why we say in our case that what the judge did in fact do was to put into that more likely to be the father and the adjunct suspicions, or as she put it, impressions falling short of findings. And if the judge fell into error, and Lord Justice Thorpe, when he said probably better, safer to leave it thus, i.e. that she hadn't done this, refers to, in fact, the judge's suspicions falling short of judicial findings she was entitled to make on the evidence. And Mr. Justice Bodie in the Court of Appeal makes the same point, that that is what the judge said she did. Seems clear from the adjunct that that's what she did in practice, because paragraph 6 was not a finding she was entitled to make on the evidence, and she didn't. And so when she explained in her final judgment what it is she did in the adjunct, that wasn't revisionist in any way. That was, in fact, a clear description of what she had done.
Where do we find that in her final judgment? Can you point to the paragraph?
Page 39, paragraph 3.1, through to paragraph 3.7. I made my findings as to the threshold and the question of perpetrator or perpetrators at the original fact-finding hearing, found the threshold criteria passed on the balance of probability. The evidence was such I could not find it proved against either of the parents that he or she had inflicted the injuries on J.
And this is after E.B.
This final judgment is after E.B. This is the judge explaining how she, on invitation, came to formulate the adjunct in the way that she did, and what factors she included in the adjunct. I formed the view neither could be absolved from being a potential perpetrator. There was a likelihood in the sense of real possibility. Each of them was a perpetrator. The allocation of that percentage likelihood is just that, an evaluation of the factors which give rise to the relative likelihood or reasonable possibility of each of the parents. for her at least, qualitatively distinct and different from findings on the basis of evidence, to establish on the balance of probability whether a fact is proved against one or other parent. My Lords, that is why I took your Lordships to point 6 of the adjunct, where there is a clear evidence that the judge was adding in, when she made the 60-40 comment, factors which she would not have been entitled.
Sorry, which
She would not have been entitled to take into account to determine perpetration.
That was, which fact was that?
That was the allegation of injury that wasn't an injury against a 2-year-old child from father's previous relationship, which she had no evidence and made no finding that he injured, that it was an injury. But of course, the fact that the allegation had been made was what she put into this further evaluation at point 6, which the judge further classified as findings on the basis of that were falling short of findings, because it was, and she couldn't have.
So because she's listed stuff that really isn't evidence at all,
Yes.
that wasn't what she wasn't making a fact finding. She wasn't doing a fact finding exercise. Is that what you're saying?
No, my lord. What she was doing when she evaluated those figures, some of them are facts that she actually found. She found, for example, the father was argumentative and angry at the hospital in drink. She found that the mother was observed to have been handling the child roughly when winding the child. But she included in the factors against father and against mother other aspects which could not be, on any interpretation, facts found by the judge, because she included observations such as there's been a past complaint about this father, albeit that, in actual fact, it wasn't a non-accidental injury. It is a happening and a comment about a happening. She's made no finding.
Paragraph 6. Is that not a fact?
It is.
It's a fact that there's been an allegation, but it's not.
There was a referral to social services as a result of facial bruises following the visit.
It's a finding that there has been an allegation. It's not a finding that the father has behaved in that way, as per the allegation to his child.
Well, she doesn't actually say that.
No.
She just says with this information, together with other things which she has made findings about.
Well, my lords, yes, but the only inference one can take from that is that those were the factors falling short of findings on the evidence that she could make. She wasn't entitled to make a finding that the father had done one thing or another. Indeed, all she did was recorded it as an observation. It really had no other status. It wasn't an evaluation of evidence. It was merely a description of a past allegation against the father.
Why wasn't there any reference to that in the body of the judgment at 57?
I think there is at page 54. But I agree, it's odd that it's not on page 57. But is it not the incident on page 54, about a quarter of the way down, 11407?
Yes.
Yes.
And so on, and then
So it's
presumably hospital unable to say deaf. Is that definitely
Yes.
NAI?
So what was it? It's simply an observation. It's not a factor. Certainly when one's trying to evaluate on the balance of probabilities whether this man was or was not a perpetrator of injury, an allegation was made. It wasn't non-accidental. It was an allegation. She records it. She can go no further with it. But she expressly cites that as one of the factors if she was asked to express relative likelihood outside of what she could find as a fact, that would tip her to the father. That's a judicial...
It's odd that she doesn't include it on page 57, where she is...
Well, she does have a generalised thing. There are allegations of inappropriate care of his other child. D.
Oh, yes,
They're
that's
both
true.
called
Yes,
D.
that's true.
Yes.
And in fact, of course, she refers to there being other incidents as well in paragraph 5 of the adjunct.
Yes, she refers to police call-outs of domestic violence, 15 in total with a previous partner. They weren't call-outs in respect of the children, allegations of harm to the children, but because they were domestic violence call-outs, obviously they were a concern for the children. And then there was also this allegation that had been made some months earlier, in April 2007, about the father and his other son, D.
And you're saying this is something that would have been is of interest at the welfare stage anyway, even if she hadn't mentioned it in the adjunct, it was already there in the
It was
in the
part and
analysis.
parcel of the local authority core assessment that the past allegations that have been made and any involvement in social services are matters that the local authority would consider when looking at issues of risk, both at the present time and indeed future risk. But it was not a finding that the father had harmed a child. In fact, it wasn't a finding that his 2-year-old had come to any harm at all. Merely that there had been an investigation because of 2 bruises on that child's face, but it went no further.
Yes. Well, now, just going back to your printed case, for what it may be worth to us, in paragraph 22, you're asking us to reject Mr. Hayden's invitation to us to allow the appeal and obviously and to substitute a finding that the father was the perpetrator. And that's, as far as disposal is concerned, that is the end of our function on your argument, as I understand it. But you made your important points at the beginning of your submissions about the significance of the report.
Yes, my Lord. Clearly, the main point that was taken, and is taken by the appellants, is that this court should substitute a finding.
Yes.
And my Lords, for the reasons that I have set out, I would invite the court to reject that. But if the court were to find that what the judge did was make a finding of perpetration, for the reasons that I outlined yesterday afternoon, then I would invite the court to reject the appellant's appeal.
This is your paragraph 24 point.
It is.
23
on the
plus
making.
24. 23 you say, in any case, we should uphold the care and placement orders. And then you explain it. I think that's right in saying it in 24.
Yes.
A little further.
And 24 and 25, in effect, is the rationale for why one should reject the appellant's contention that the court should replace the care orders with interim care orders, or not at all in the case of the child W.
Yes.
And the reasons I've already given, that in fact, at the welfare stage, the risks that the assessors should have taken into account, did take into account, indeed, ironically, took into account on the basis of a 60-40, rather than a finding that the father was the perpetrator as a matter of law. That's really the only difference in terms of what the assessors were doing.
Well, thank you very much indeed for your assistance. Miss Watkinson, do you wish to add anything?
No, thank you, my Lord.
Thank you very much. Well, Miss Judd.
My Lord, so far as the guardian is concerned, we don't depart from the printed case that we have provided to this court. That is to say that we support the appellants on their submissions in relation to the law, but we depart in relation to the facts of this case.
Yeah.
That is to say that we agree that there was an unintended consequence following the H, of course, applying an elevated standard of proof in cases where serious allegations were made. And that had a knock-on effect when considering perpetration. And we say that that's absolutely clear when we look at the Court of Appeal cases, particularly Rie. And Lord Justice Thorpe saying that the judge at first instance considered it's rather a likely perpetrator, or that both parents were in the frame, one parent was the more likely perpetrator. And the only analysis of that, we say, is that courts will generally apply a heightened standard.
Sorry, which judgment of Lord Justice Thorpe was that?
My lord, that's in the reading.
I thought you said Rie.
Divider 4, paragraph 16.
Yeah, Re D, I think, is a judgment. I mean, Lord Justice Wall, you would endorse, would you, in Re D? Yes.
Yes.
Paragraph 16 to 17.
Yes.
And we say that really the only interpretations. And also,
I'm sorry, do we also, I mean, does this phrase of his in the case we've got, where, I've now forgotten what the striking depart, whatever he said, what did you say?
oh yes, it's
Sweeping departure. I mean, is that the same point? That illustrates how he thought that actually H did stand for a heightened test.
Yes, and in fact, I have taken your lordships and my lady to be the wrong case first, as it were, because that's most obvious as well in the compelling medical evidence, where he talks about the heightened standard of cogency being required to exclude the parents.
Where's that?
Potential. That's in B, compelling medical evidence. That's first in time. Divider 16, paragraph 38.
Which we've seen earlier, I think.
I mean,
Though he then says he didn't quite mean that in Yorkshire.
but
Yes.
well,
Your only point is that there was a common belief that there was a heightened standard of proof in relation to serious allegations and in relation to identification of perpetrators, at least until Re B. That's what you're saying.
absolutely
Yeah.
right. And the combination of that plus Lord Nichols' remarks in the ONM, which we've all gone to a number of times, whatever Lord Nichols intended by those remarks, led counsel and judges and people involved in such cases to ask judges for indications as to relative likelihood. And that's what led to what happened in this case. That's what we say. I don't want to run through this too quickly if anybody wants to take it back, because I'm very conscious that we have a day and a half of carefully to the authorities. But what we say is that Re B stated the law and clarified the law and put at rest and gave it quietus the doctrine of the elevated standard of proof. That applies when you're finding facts to establish the threshold. But we also say that Re B was right when it applied it to establishing a perpetrator. It's got to be on the balance of probabilities.
Yes.
What's the consequence of finding on the balance of probabilities if it's a narrow balance?
Well, we would say, and we well appreciate that there are difficulties with this, but you've got to have a binary system. So therefore the consequence is, if you decide that X is the perpetrator on the balance of probabilities, then X is the perpetrator.
You shut your mind, do you, in deciding where this child is to go, to the real possibility that actually it wasn't A, but it was B. You've actually got to shut your mind to that. That is your submission.
Yes.
Thank you.
And where is that in section 31?
I'm very conscious that does leave difficulties, but any test you apply does. And of course, you won't normally be having a different judge trying part two, if one can call a case in.
Of course, Lord Hoffman goes quite a bit further than that. As in paragraph 2 of his speech, he says, doesn't he, if the party who bears the burden of proof fails to discharge it, the value of naught is returned, and the fact is treated as not having happened. So the logic of that, if you apply Lord Hoffman's binary approach to the question, was F the perpetrator, you get, and the case fails, you get naught, and therefore the father was not the perpetrator, applying Lord Hoffman's analysis. So you can't apply Lord Hoffman's analysis to that question, can you? Because because the cases don't then proceed, because all the cases we've looked at,
yes,
which discuss what happens if the judge can't find out who the perpetrator is, analyse the real possibility of all that stuff of Lord Nichols about how that would be quite contrary to the purpose of the Act and so on. So, with great respect, your argument proves too much if you rely on paragraph 2 of Lord Hoffman.
The difference between, there's a difference between the threshold.
So you can't apply the reasoning of Lord Hoffman.
No, well, you go back in the pool. You go back, if there's a real possibility that you are a perpetrator, you're then in the pool.
You may be in the pool, but then when you're in the pool, and when the next judge comes around to consider what the court should do, having regard to the fact that there is a pool and there are possibilities that A, B, or C might have caused the injuries and the like, those are all factors to be taken into account in deciding what should ultimately be done.
Then you're a possible perpetrator, and that's got to go through to the next stage.
So you don't get naught then, you are a possible perpetrator, which is the contrary of the point you were just arguing.
Yes, sorry. What I was trying to say, that if you identify X as a perpetrator, then what you can't do is consider Y as a possible perpetrator.
Well,
Y is then not a perpetrator.
Why not?
Because you've found that X is, and that's perhaps a slightly different.
But you can't get that from, my point is that you can't get that from Lord Hoffman's analysis.
Can you get that from O and N? Is where what the ratio of O and N is, that if you
can't, because the O and N isn't such a case.
O
and N's a case where you couldn't find who the perpetrator was.
Yes.
It isn't authority for the proposition it doesn't tell us what the answer is. If the judge can find that A is the perpetrator, it doesn't tell you whether you can take account of the possibility that B may have been the perpetrator.
Excuse me if I'm getting muddled. O and N is authority for the proposition that if you can't find somebody did it, then they're both. Then you have to proceed on the basis that they're both possible perpetrators. There is no obvious authority, perhaps apart from Re B, of the factors found. But yes, that is relating to the threshold, the finding of the threshold. That is what.
Do you say Re B is right or wrong? That's Re B, sorry, the one we were just...
Yes.
The one at tab...
3.
Yes. But it's obviously right on the threshold.
Yes.
But it doesn't actually have to address the second stage.
But I'm advancing, or we're advancing the proposition that you should still, if you should still apply the balance of probabilities to identifying a perpetrator, and if you identify one, then you shouldn't consider the other possible.
All the risk factors have gone into that decision. Are you saying that the process of reasoning has to be discarded at that stage? If you reach Lord Hoffman's 0, that's an input, and you have simply no risk factors that add up against the
well, there may be risk factors which are entirely relevant to, which aren't relevant to perpetration.
They might be very relevant to perpetration, but they don't actually tip the balance far enough for a finding balance of probabilities to be made. But they're nevertheless things that the judge has taken into account. Said so.
Well, it depends. If they don't go to perpetration,
are we getting a bit? I'm wondering, and this is a really difficult conundrum. I'm wondering whether we're talking a little bit loosely about risk factors as opposed to evidence, which is a thing that family lawyers tend to do. If you're trying to make a finding of fact, you're looking at the evidence, which leads you to make a finding of fact.
Yes.
Now, some of that evidence may be about risk factors, but the mere suspicion that somebody's a heavy drinker, for example, I can remember a case where I had exactly this. But the mere suspicion that somebody is not evidence that would lead you. It's a risk factor. And so you have to try and separate out the two different things. And what are they? And if they're a risk factor, what are they a risk towards? The various risk factors in this particular case were basically, most of them, risks towards failure to protect from other people. Not that there was failure to protect in this case, because the judge couldn't find that, but they would lead her not to be able adequately to protect her child from the various stresses to which she was subject. Now, there are all of those risk factors. It's quite tricky to work out which of those would actually lead you to say that she was the person who bruised the child. That's what I'm trying to get at. There are different risks, and that matters that you address what's relevant to the different risks and identify what the risks are.
Yes.
The point which we were just left with on looking at the addendum and the reference to the allegation, the referral, I mean, that's not evidence of actual harm.
No.
On the other hand, it is obviously being brought into account, I think, by the judge, something is relevant to risk if you're assessing risk.
Yes, although of course she was using that to form part of her 40%.
But then she's made it clear at page 39 that there are two different exercises which we saw. The fact-finding task proper, and which she said is qualitatively distinct and different from the evaluation factors which should come in at the later stage.
Well, that's why we would say that you have to be careful before endorsing what she says as being a finding that the father did it, because she's not taking into account the right. Well, she says she's not. She says she's not doing it on the basis of evidence, and therefore that shouldn't be therefore endorsed as a fact finding. One of the things that I was going to go on to say is in going back and looking at the question of what you do if you identify somebody as the perpetrator, how you then regard anybody else, is that you should only identify somebody as a perpetrator on rigorous testing of evidence. And there's nothing in the standard of proof that says that you shouldn't do it extremely carefully, and that you shouldn't do it on propensity, and you shouldn't do it because somebody's been violent before, you shouldn't do it because somebody's a drunk, because both those things may actually make it very hard for that person to be lived with, and it could actually make it more likely that the other individual might take the various stresses in the relationship out on a child. So you have to be extremely careful what you bring into account. And so,
isn't propensity evidence for this purpose? I thought it isn't a criminal case nowadays. Why isn't it in this case?
Yes, it is, but never by itself. That's what we would say. Yes, but you have to analyse. If you were trying to decide who was a perpetrator, you should analyse it in much the way that you analyse evidence tending to non-accidental injury or otherwise. That is, you look at what happened, you look at the various accounts, you look at the events of the night, and the history that people give, you look at the medical evidence, you put that as all part of a picture. But the danger that you could fall into, especially when you're only considering two people, that it may be always a bit more likely that it's one than the other. Because if you've got somebody, say, who's hit somebody before, especially a child, that may be all you need to say, well, if I had to guess, I'd say it was, that there's a risk if you're not careful of not doing it on properly rigorous testing of evidence. But if you do that, and then you decide that you can make a finding on that evidence, then to bring into account the fact that somebody else might have done it is to unduly complicate things and to risk falling into the sort of muddle, perhaps, that...
But why is that? Because in a case where you can't, it's common ground, isn't it? In the case where you can't find on the balance of probability it was X, then at a stage, the judge has to consider the risk that A or B may have done it. And in that kind of case, nobody says, oh, well, you can't look at it, it's, oh, well, it's... Nobody says all this, oh, well stuff. So all your, oh, well point, if it's good, ought to apply in that case as well as this. So to my mind, if you can do it in that class of case, then there's no reason in principle why you should say that the one factor that's irrelevant in the case where you can find on perhaps a narrow balance of probabilities that it was F, that you shouldn't have regard to the risk in just the same way as you would in the other kind of case, that M may have been responsible. To exclude it as irrelevant, of course, there are a myriad of factors. One has to be very, very careful. I quite take my lady's point and the point you're making, that these are things which judges have to do. You have to take account of all these factors. And just one last point. When I suggested to you that, when I asked you whether re B was rightly decided, I really meant re A. Or at any rate, I meant the case at tab 4. Because I've got a bit of a muddle between these cases. This one's called re-A child abuse, and it's the case in which, well, I mean, you probably know all about these cases much more than I certainly do, but it's the slightly curious case in a way because of paragraph 16 of Lord Justice Thorpe, is it? Judgment, where he seems to be saying that it's more likely than not that the mother was well, he says that the mother was the more likely perpetrator of the ankle injury. But then, he says, even though that's the case, the judge, that you couldn't exonerate, the judge was right to say that you couldn't exonerate either parent. Now, is that analysis right or wrong, or what?
Well, on the proposal that we were putting forward, wrong.
But on the discussion we've just been having, right?
Yes, well, it could be.
It slightly depends what he meant, I suppose, by more likely.
And also exonerate.
And exonerate, yes.
See, it's words like exonerate and exculpation that worry me a lot.
I agree.
Because it is looking as if it's setting up parents. Now, once your child has been injured in your house, unless you can prove 99% that you didn't do it, you are going to be still regarded as to blame for that injury. That there's ways in which the language seems to suggest that, and that seems to me to be unjust and bad for children. We have to be a bit more precise about it than that, and a bit more careful about making our distinctions. We're really saying, well, can we find that X did it? Can we find that there was a sufficiently serious possibility that Y did it, that we have to take that into account in deciding where the risks to this child in the future lie? I'm summing up something, I think.
Yes, I mean, it's extremely difficult. I put a proposal suggesting that if the judge at first instance, and it should be the same judge going all the way through, only makes a finding if he or she is not satisfied, but on the balance of probabilities, on rigorous testing of evidence, that the proposal we put forward is that then should operate as that individual was responsible, and you shouldn't take the other into account. That's not the only way of doing things. That another possibility exists that you the judge is able to say, well, it must be fairly unusual for judges to talk about percentages.
I wonder whether we should just break off at this point of view at the time and come back at 2 o'clock. Thank you very much.